मिशन चढ़ती कला। और मैं भारत के हर नागरिक को, उद्योगपति को, चैरिटेबल ट्रस्टों को, कलाकारों को, पूरी दुनिया में बसते पंजाबियों को, बहन भाइयों को दिल से अपील करता हूँ, आओ पंजाब को दोबारा अपने पाँव पे खड़े करने का टाइम आ गया है। पुनर्वास में और रिस्ट्रक्चर में पंजाब का साथ दीजिए। मैं वचन देता हूँ, जो भी आप मेहनत की कमाई से 1 रुपया भी अगर निकालोगे तो 1.25 रुपया बना के हम पारदर्शिता और ईमानदारी से इस्तेमाल करेंगे। और जानकारी चाहिए तो rangla.punjab.gov.in ये वेबसाइट पे जा सकते हैं, सब कुछ डिटेल मिल जाएगा। आओ मिलकर हाथ से हाथ जोड़ के एक ऐसा पुण्य उसमें योगदान डालें और बता दें दुनिया को कि पंजाब किसी भी संकट के सामने हारता नहीं है।
Welcome back, viewers. You're watching the Savera and I'm Shefali. The Karnataka High Court is scheduled to pronounce its order today in the high-profile legal battle between social media platform X Corporation, formerly known as Twitter India, and the Union of India, concerning alleged censorship and restrictions on freedom of speech. The matter is listed before a bench headed by Justice M. Nagaparsanana, with the verdict expected at 4 p.m. The case has seen detailed argument and counter-argument submitted by both sides. Senior counsel K.G. Raghavan has representative X Corp, while the Union of India has been represented by Solicitor General Tushar Mehta and Additional Solicitor General Arvind Kamant. X Corporation filed a writ petition in March seeking interim relief against what it described as consular action by the government that threatened its operation and free speech principles on the platform. At the heart of the dispute is X Corporation's contention that certain orders from the government, particularly in connection with the Sanyog portal, referred to the company as censorship portal, amount to unregulated censorship. X argues that directives issued under the Informative Technology Act, including Section 69A and allegedly misused provisions of Section 79(3)(b, compel the platform to remove content selectively, often involving posts from opposition leaders and critics. The company claims these actions bypass established legal processes, threaten its business model, and violate principles of free speech. The matter is not new. In 2022, X Corporation challenged orders under Section 69A that blocked entire accounts through the Karnataka High Court. At that time, upheld the government's authority to take such action in the interest of sovereignty, security, and public order. Now, in the current petition, X Corporation has reiterated its stance that compliance with Sahyog portal's directive constitutes an overreach, creating a system of censorship without judicial oversight or procedural safeguards. The Union of India, on the other hand, has maintained that its power to regulate online content are clearly defined under the IT Act. Counsel for the centre argued that restrictions under Section 69A was legally justified to protect national security, sovereignty, public order, and to prevent the commission of offences, and that no punitive action has been yet taken against the X Corporation for non-compliance. During a March 17 hearing, Justice Nagaparsanana has allowed X Corporation to approach the court if the government undertook any precipitative action against it. Since then, the case has attracted widespread attention given its implication for freedom of expression, intermediary liability, and the regulation of social media platforms in India. Observers note that the verdict, once delivered, could set a significant precedent on how Indian government interacts with social media companies, particularly in matters where content moderation intersects with political discourse and national security concerns. The outcome is being closely watched by technology firms, legal experts, and free speech advocates, as it may define the boundaries of regulatory authority and platform autonomy in the country. That's all for now in this update. Stay tuned to the Savera, download the app, and follow us on various social media platforms.